and welcome to a Hanakako. I'm Keli'i Akina, president of Grassroot Institute. We're a weekly program on the ThinkTech Hawaii Broadcast Network. As you've read the Constitution of the United States and the Declaration of Independence, I'm sure you're familiar with some grand language that has made it into our culture today. Life, liberty, and the pursuit of happiness. But as many of you realize, once to our founding fathers, the catchphrase was life, liberty, and property. There's somebody who knows why and knows what the importance of property is today. His name is Robert Thomas. I'm delighted that he's on our program as a guest today. He's managing lawyer or managing attorney for the Pacific Legal Foundation here in Hawaii, an expert in property law and many matters related to the Constitution. We're going to have a robust conversation today, and I know you're going to enjoy meeting my friend Robert Thomas. Robert, welcome to Ehana
Dr. Akina, Keli'i, thank you. Thanks for having me
Always
today.
good to talk with you because we talk about the big ideas.
Well, we hope so. I mean, lawyers, we can sometimes get bogged down in the details of a case, but the stuff I work on many times has large implications.
Absolutely.
For us.
Well, you know, a lot of times I talk with some attorneys and our conversation it never leaves this earth. It's more about money or investments or winning particular cases and so forth. But when we talk, we get to talk about the importance of some great ideas that founding fathers gave us, and even great philosophers before that, like John Locke. How important is it for us to have a sense of history, a sense of the philosophy that has led to our law, if we're going to practice law today?
Well, it's very important because of the system we work under, the common law system, which was brought over to us from England and other what now are Commonwealth countries.
In fact, why don't you just expand briefly on what common law is, and then keep going with your thought here.
It's judge-made law, essentially. I mean, you go to the European continent, the Asian countries, laws come out primarily from legislative-type bodies. But England had a tradition where judges would make law and essentially fill in the gaps.
Sure.
And it's the law of custom. So this is how we've always done things, and it's a very progressive, slow-moving, but changing and evolving system. And so it takes into account the way people think and live, not just what a legislature decides this is going to be the new code section about some subject. So it's a very citizen, person-oriented system of law that gradually changes over time and adopts to the way we live and work.
I would imagine that in a democracy, common law and other precedents to the law or antecedents would help to inform us as to what the people have been thinking, what the polity has been thinking about values, about great concepts that are dear to them.
Exactly. I mean, that's one of the, I think, the brilliant points of our system is we now have become sort of this mixed system with a constitution, state or federal, a legislature adopting statutes or a city council adopting ordinances, and then judges and juries filling in the gaps, taking the law, not necessarily where those legislative bodies have thought about it, and understanding, applying their knowledge of the common person. That's why it's called common law.
Sure.
Not because it's beneath us, but because it's something that we all share.
You're saying that there is a background to the ideas that inform law that sometimes we don't take into consideration when we're just considering, is it legal or is it statutory or is it something fitting with the current body of governance and so forth. And so what happens when that takes place, when we're merely technical about law, but we forget perhaps the spirit of the law?
Well, that's when you end up with decisions that don't make sense or rules that don't make sense. That there are supposedly legal principles to help you avoid doing that. But you see that in cases where, for instance, we don't have them here anymore. I'm not sure we ever did, but Sunday blue laws or law. You know, you always see those on websites or whatnot about these sort of crazy on Sundays, Saturdays you can't do this, or you can't walk down the street in some town with a certain type of drink in your hand or something. And that's a time when it made sense perhaps at one point in time, but it doesn't make sense today. So the law is constantly changing. What we think about what is the law with a capital T, capital L changes. You see it constantly in the newspapers, whether it's in the headlines, the editorial section, letters to the editor saying, why can't they just follow the law? Well, first of all, explain to me what that is. And each of us, I think, brings a conception of what that might be. Now, I think we have some shared understandings, and you hope you do, particularly in American society, about we have sort of shared values that have become part of our Constitution. And I'm never quite sure which came first. Do we believe, Americans believe in democratic principles. They believe in the right of people to say and think and believe what they want. Now, is that something that predated? Do we have a constitution because those were the values?
Sure.
Or is it those values that we share today because somebody 200 plus years ago said, these might be good Enlightenment ideas. Let's write them down and say this is sort of the overriding principle of this government, and we've become acculturated to that.
Sure, but in terms of the growth of our government and statutory law, it may look like a chicken and the egg situation. I tend to think, Robert, that some of these great ideas have been around since the beginning of civilization. And as we go back to the Egyptians and then to the Greeks and Romans and then through the Middle Ages, we find the development of these ideas and the real genius, I think, of our founding fathers in 1778 and that time period is the ability to bring these ideas which have existed long together. I want to ask you something. Sure. I was recently talking to an attorney who became very frustrated with me because he basically said, when you're talking about people's rights, Keli'i, quit quoting the Constitution and the Bill of Rights.
Oh, okay.
And then he said, we all know that rights are determined on the courtroom steps. And I thought about that for a moment. And isn't that sad that we think of rights as being reduced to what could be won in court, as opposed to a concept that even precedes and supersedes law itself?
Well, I mean, the founding principles of this nation are that we have inalienable rights, which means it's not up to the government or a court to give or take them. We have them by virtue of the fact that we're human beings. And that's, I think, if you keep that in mind, the rest sort of falls away. But we forget that. We start thinking of the distinction supposedly between rights and privileges.
That's right.
Do I have a right to speak freely? Do I have a right to worship in the church that I want to worship in? Or is that a privilege that the government gives me? And the founding principle was that we didn't need the Constitution to tell us we had these rights. I mean, it was a completely radical idea at the time.
Sure. In other words, rights themselves actually exist.
Yes.
Whether or not there's a government to say so, and a proper government would merely reflect the fact that
that's
they
exactly
exist.
it. And they were in the terms that they used, God-given rights. By virtue of the fact that you're born, you have them, whether or not your government or your fellow man recognizes them. What we would probably call today human rights. It's a right inherently that you possess, and it doesn't take a Bill of Rights to protect them, supposedly, although that of course helps because of our system that we're used to, the common law system.
Now that leads us to the very intriguing title we gave today's presentation, Life, Liberty, and Property, something which we don't say a lot today, but that phrase, life, liberty, and property, which ultimately became life, liberty, and the pursuit of happiness, is one of the most concise statements of rights.
Yes.
And at the time, property was considered a right, or at least what was implied by the ability to own property and not have the government take it away from you and so forth. And that's your whole area of specialization.
And there was a good case to be made that the founders believed, as well as the adopters of the 13th, 14th, and 15th Amendments after the Civil War, which are sort of the second founding, in my view, believe that property was the foundational right of all those, and without property, you could not really have life or liberty or freedom of speech or other things. So there's a wonderful book written by a law and history professor at Vanderbilt University, James Ely, called The Foundation of Every Other Right, about the history of property rights in the United States. And he said, if you can't own something and the government or your courts or your fellow man won't protect your right to keep others from taking something away from you, what good is your freedom of speech?
Right.
What good is your freedom of religion? And whatnot. And he's made, I think, a very compelling case. And it's not a very short book, and it's not a very difficult book to read. So I always tell my fellow lawyers, if you want to see what fuels my ideas, start with that book, The Foundation of Every Other Right. And
Well,
it's a wonderful book, and I actually think that it's true.
Yeah, absolutely, and this is exactly what John Locke thought back
Right.
in the 17th century. He didn't coin the phrase, but probably he's been credited with this more than anyone else: life, liberty, and property. But it didn't simply mean that we're something physical like real estate. Property was a much broader concept, wasn't it? It was the right to myself and to the labor that I enhance that property with, and to the mere capacity to have ownership as opposed
Yes.
to be owned.
And that you hit that one phrase you just mentioned, and that's it: the right to the product of your own labor. I'm more of a lawyer than a philosopher or a true student of this. So forgive me if my understandings of this turn out to be sort of a little bit off. But my understanding of it was that the basic theory here was not so much that you could own something, but that something represented the fruits of your labor.
In fact, yes.
And your liberty and your freedom. So the fact that if somebody takes away your property unjustly,
take away your liberty.
they take away your liberty because you
Exactly.
earned that by your labor or the sweat of your brow.
I would love to underscore that and shout it from the rooftops that if somebody takes away your property,
Right.
they take away your liberty. In fact, I think that's part of the reason that Thomas Jefferson opted for the statement, life, liberty, and the pursuit of happiness. It is not to deny what John Locke was saying about property, but to recognize it was a broad concept.
Yes.
And Franklin, you may recall, Benjamin Franklin felt a true right cannot be taxed.
Yes.
So if we say property is a right, we're saying the government can tax our right. So without denying that it includes property, Franklin and Jefferson felt the pursuit of happiness was a great phrase that in a noble, well, a great phrase that summed up something the government could never tax, could never prevent. A right, the pursuit of happiness, but included property in their mind.
Well,
the ownership of property.
There's been I think a compelling case made that what we think of, nowadays you think the pursuit of happiness. Oh, I can do what I want. I am searching for my joy, my happiness.
A very subjective definition.
And there was a compelling case made. I can't remember in which book it was that I read that said happiness at the time of the founding actually meant. I don't want to say work, but pursuit was the key word, and we tend to focus on pursuit of happiness. And at the time, that they might have been more interested in emphasizing the word pursuit. So it's the pursuit of happiness that our government was formed for, not necessarily the happiness itself, because each of us is free,
absolutely,
whichever direction we go.
And that speaks in many ways to the American spirit, that there are no guarantees, there are no promises, but there are opportunities and the pursuit.
And we speak
of
these days of pursuing a profession. For instance, it's not like we're chasing the profession or pursuing happiness, but it's the work of happiness, and in essence, that's what they were suggesting that the government was formed for, is to protect the people's right to continue to try to find happiness by themselves with their life and their liberty.
Sure.
Because if their experience was, if their lives were taken away unjustly, of course that's the worst. Liberty being the next worst thing, and then the final thing being you could not. You were being bound into certain types of servitudes or whatnot. Ironic, of course, given the history of slavery that we finally rectified, 85 years later. But again, nobody said we were perfect at the start.
Yes.
But we're trying.
I'll date our program today if I make reference to something which happened in this past week in the Honolulu City Council, and that was movement for the increase of property taxes to a significant level. Now, rather than argue about that, I just want to reference what you're talking about here, and that is, it's not just about financing the city. It's not just about a legislative measure. There are some very deep values involved when we talk about property that touch upon the rights of the people and the right to pursue their happiness.
Right. And property taxes, there's no question that generally they're constitutional, that they don't offend sort of the freedoms that we've been talking about. But again, they have to be tied somewhat to the services you receive.
Yes.
Other than that, they become arbitrary and capricious, to use lawyers' language.
Absolutely.
And simply a tax for not being able to take your property and move to Nevada, for instance. You can move, but you've got to leave your property behind.
And ultimately, we have to see, as in the thinking of the Founding Fathers, property is not merely disconnected as a mere commodity. It's part of the capacity to pursue happiness.
Yes.
And when we attach anything to the property of people, we are in some ways mitigating their right to pursue happiness. We'll be right back in a second,
so.
Robert. I'm going to say goodbye to our guests for a few moments. This is ThinkTech Hawaii's weekly program called E Hana Kako. I'm Keli'i Akina, president of Grassroots Institute. My guest today, Robert Thomas, is with the Pacific Legal Foundation, and we're talking about life, liberty, and property, the importance of those big ideas to the way we live and to the democracy we have today. We will be right back after this short break.
Aloha, this is Jay Fidel. You know, ThinkTech and the Hawaii Venture Capital Association put on monthly luncheon panel programs at the Plaza Club here in Pioneer Plaza. Our program this time is on September 26th. It's called Solar in Hawaii. We're going to examine the solar industry and see what's in it for the long haul. We have a great panel, great moderator. We'll be sending out email on this. If you want to be in our email list to receive the details, check out thinktechhawaii.com. In any event, you can sign up for the program at hvca.org. Thanks. See you there. This is Jay Fidel. Mahalo.
Aloha, my name is Mike DeWert. I'm the Chief Scientist for ThinkTech Hawaii. I'm also on the board of the Hawaii Academy of Science, and I'm the Energy Chair for the Environmental Caucus of the Democratic Party of Hawaii, amongst other things. Next week, on the 19th of September, I'm going to be doing a show with Jay. The topic will be how the 18th century had technology too. We'll talk about some of the technologies our ancestors had that we have forgotten and that we're going to need if civilization ever collapses. So, hope to see you then, and mahalo nui.
Hi, I'm Donna Blanchard. I'm the host of the Arts in Hawaii on the ThinkTech series. I'm also the managing director of Kumukuhua Theater in beautiful downtown Honolulu at 46 Merchant Street. Right now we have an incredible show running called Will the Real Charlie Chan Please Stand Up? The Charlie Chan was based on a real-life detective right here in Chinatown, and Nancy P. Moss has written a wonderful script that Reiko Ho has done an excellent job of directing. It's running at Kumukuhua until September 22nd. You can find more information at kumukuhua.org. I hope to see you there. Aloha.
I think this for other reasons, but yeah.
Well, we're going to welcome our audience back.
Good.
Aloha, this is Keli'i Akina with the Grassroots Institute, welcoming you back to E Hana Kako, a weekly program on the ThinkTech Broadcast Network. My guest today, Robert Thomas with the Pacific Legal Foundation, is chatting with me about life, liberty, and property. We'll come back to that property side of it once again in a few moments, but first I want to get into the life, the causes. What were the causes that have led to your becoming a lawyer? I mean, of all professions in the world, when you were in the crib, looking out, Robert, into the world, what drew you to this profession, ultimately?
Well, I guess when I was popped out at Tripler, and I'm
so you're a military brat?
Yes.
Growing up here in Hawaii?
Up here in Hawaii, born here. A mother grew up on the plantations.
Well, how about that? Now, I want to acknowledge for our global audience that a lot of folks here in Hawaii grew up on military installations, I myself included, and there's this real interesting mix between the military and the local population.
Yes,
but go on.
No, so Dad was from upstate New York. Mom was a local girl on the plantation. Grew up on the Halava plantation. In fact, right where the Aloha Stadium sits today.
There you go.
But Dad was off in Korea at the time. This was 10 years, I guess, after the Korean War, and Mom drove herself down to Tripler Hospital and had me. And I can't say that the first thing I thought of was I just want to be a lawyer. It was I was in university on the mainland, and doing about the third year, thinking, what would I like to do? And I had never thought of the law as a profession. In fact, it was probably one of the last things on my mind. And then it was either that or go full time into. I was going to follow my dad, go in the Army. So I thought, maybe Army or law. And I thought, well, I'll take the entrance exam, see if I get in. and lo and behold, did okay, and applied to the fairly new UH Law School, which had been producing lawyers for roughly about 10 years at that time. This is in 1984.
Which is now known as Richardson Law
Richardson
School.
Law School.
That's right.
In fact, it had been recently renamed and moved from the old facilities down in the quarry down below up until where it currently sits today. And so I think we were either the first or the second class to utilize these brand new facilities. And it's very selective, that school, because so many people want to get in, and it's one of the smaller law schools. And for some reason, they let me in.
Not another American law school for 5,000 miles around.
Exactly, right? I mean, the closest one's probably in San Francisco, I suppose. And for some reason, they conceded to let me in and let me sneak into the law school.
Well, I've got a question about that. There have been some outstanding graduates, yourself included, who have gone on to distinguished careers in a variety of fields of law. What is your thought about the role that the school has played here in Hawaii? Because there was a time when we didn't have our law school, and now we can look back and say, after how many, hundreds of lawyers have graduated, what do you think the impact of the Richardson Law School has been?
Just celebrated its 40th anniversary from its inception, and there was a sense at the time, I guess, that the state university system was not complete without people. You could get a law degree in the mainland. You could go to Hastings or UCLA, come back and practice, and people had been doing that for quite a long time. But there was a sense that something was missing, the local touch, because we all know that we here in Hawaii believe that we understand our environment better than anybody else. And so it was, as I understand it was formed with those principles. And I think it's done a fairly good job. I mean, you look at, some people might say, oh boy, that's just what we need, more lawyers, that even if we didn't have the law school. I have no doubt that there would be enough lawyers here, but would they understand the court system and whatnot? And so it's the leadership, I think, of some of the graduates, whether it's in academia. I mean, it's produced some outstanding scholars, practicing lawyers here in town, judges. I think Sabrina McKenna, Associate Justice McKenna on the Hawaii Supreme Court, is the first graduate of UH Law School to become a justice. And then also spread out. When the school first started, most of its graduates remained here in Hawaii. So you have John Waihe'e, for instance, the first
former governor,
first class of graduates who became governor not long thereafter. Many people became politicians, judges, attorneys. But now, I think, as the reputation and the professionalism of the school has grown, it's spread out where you have professors on the mainland who are UH law graduates, deans of law school, all sorts of things, practicing lawyers. They're not just limiting themselves to Hawaii. And of course, as Hawaii becomes part of the world through the internet and the ease of travel, it's been, I think, a great resource. And you're speaking to someone who I feel that in a sense I've taken advantage of the taxpayers of Hawaii, because back in the 1980s, resident tuition was just a steal. And once the school offered me a spot, there was no way that I could say no. But I feel somewhat guilty about that.
Sure.
So try to give back a little bit, because I think that the taxpayers gave me a break on tuition.
And you've done more than simply pay your taxes. You also practice what we would call public interest law.
Correct.
With the Pacific Legal Foundation.
Yes.
And I wanted to ask you a little bit about that. Not everyone in our viewing audience may know what public interest law is and why it plays such an important role in our society. So would you kind of describe what that is, and as well as some of the areas that it touches upon?
I mean, one of the functions of courts is to resolve disputes between people. We don't want people, at high noon having a duel. And so it's used in cases where people are injured, agreements break down, business breaks down. Rather than fighting, they sue. They hire lawyers and resolve those disputes. But has become, and maybe in the last 60 years or so, the courts have become an alternative forum to resolve what I would call policy disputes. So you see the rise of the U.S. Supreme Court as becoming more important, I guess, in deciding cases that affect you and me on a daily basis. Up to maybe the beginning of the 20th century, the Supreme Court, while it decided issues of government and whatnot, and of course a very few very, very critical issues such as slavery and other things, for the most part, the courts resolved private disputes or disputes about the structure of government. But these days, courts have become if you can't win in the legislature, sue and get courts to make the rulings that you should be. And there's been some criticism of that. But while we tend to think of groups like the ACLU for the First Amendment, the Sierra Club doing it for they have a policy goal and they use litigation, court action as a way to further that goal. But the same is also true for libertarian and conservative organizations, or like mine, Pacific Legal Foundation, a legal organization that was formed specifically to protect liberty, freedom, property, and looking for cases, finding cases, and making, quote unquote, making law that will further those principles. So when we talk about public interest litigation, it's not just to resolve, you agreed to rent your house to me for 3 months and it's not habitable. Who's right, who's wrong, who has to pay? It's about bigger questions.
Sure. Now, what role does public policy, law, or practice play for balancing out the power within a democracy, particularly for minority groups that may not have the political power within a state, but have values that are deeply entrenched, that are of value to the people? Obviously, the courts give another recourse for being able to affect policy. How important is that role?
Well, it's huge. I mean, and we see it in what I would call the more well-known areas. There's a reason, for instance, the ACLU is very good on protecting freedom of speech, because people who say unpopular things tend to be pretty unpopular. They're not going to get what they want or need, the protections that they need in the legislature, because that is, democracy in action. And democracy, another word for democracy is what does that joke say? It's two lambs or two wolves and a lamb deciding on what's for lunch. It can be, if it goes too far, it can be mob rule. And the way our constitutional structure is, the framers of the Constitution, whether that's the U.S. Constitution or the Hawaii Constitution, it put certain things, I don't want to say off limits, but for instance, if there's, for instance, in speech rights or property rights, that is, again, supposed to put the brakes on popular passions. So even if the legislature goes overboard in its passions, you still have the courts as a backstop enforcing these higher principles, saying, wait a minute, you put this provision in the Constitution to protect somebody like this, we're going to do that. So it's absolutely essential, I think, the court system, lawyers, judges, juries, in protecting minority rights. And by minority, I don't necessarily mean, ethnic minorities, but anyone with a view that's not the prevailing view, or the prevailing skin color, or the prevailing religion, or thoughts, or anything like that.
Well, many of the views that are expressed at Pacific Legal Foundation, for example, would not necessarily be the most popular views in the state. They might be minority views.
That's correct. Very much so, I think.
Could you give us an instance of one of those values and the kind of court case that you may have fought in order to prevail?
Several things. I mean, there's a good example comes to mind from several years ago, back when I was fairly new to Pacific Legal Foundation, and it was the county of Kauai. The people of the county of Kauai adopted a charter amendment to keep their property taxes in control, because here in Hawaii, under state law, the state has delegated to the counties, of course, the power to implement property tax policies and do that. It's a little bit different than on the mainland, and in fact, that's, I think, the only way, short of legislative largesse from down here on Baratania Street, that counties can generate their own
Revenues.
Exactly. It's property taxes. We don't have local school boards like they do on the mainland, whatnot. So property taxes are really where the local governments get their operating funds from. And there were no controls in them because it's tough for a city council to limit themselves, for instance, like the voters of California did in Proposition 13. But essentially, the voters of Kauai, through the charter, adopted a measure much like California's Proposition 13 that said if it's the date, the valuation of your property is the valuation on the date you bought it, plus a cap on what it could increase every year. So at least homeowners would know from year to year. They wouldn't all of a sudden get a letter from the assessor saying, boy, we've looked at the increasing property values and, a lot of people on fixed incomes, longtime families, and whammo, your property taxes all of a sudden jump up 30% or something because the equity in your house has increased, even though the cash in your pocket hasn't. And so they adopted this measure.
Well, you know what I'm going to do, Robert, is invite you to come back in just a few minutes and finish that intriguing story, because we've got to take a short break. And we're talking with Robert Thomas here, Pacific Legal Foundation. I'm Keli'i Akina with Grassroots Institute. When we come back, we're not only going to finish up this story of what happened on Kauai, but we will focus a little bit more on Robert's area of expertise, which is property law, especially as a public interest lawyer. We'll be right back just after this very brief message.
I'm Bill Spencer, President of the Hawaii Venture Capital Association. We do monthly luncheon programs with ThinkTech about things that matter to Hawaii entrepreneurs, investors, and business service providers. So join us on the fourth Thursday of every month at the Plaza Club. For information about upcoming events or to join our mailing list, visit hvca.org. See you there.
Aloha, I'm Hong Jiang at ThinkTech. I'm a host for Asia in Review on Tuesday afternoon between 4 to 5 p.m. At our programs, we learn about what's happening in Asia and why it is important for you to know about it. So I'm Hong Jiang, and I'll see you there.
Thank you.
Okay, how are we doing?
We're
All
doing
right.
great.
Okay,
I think.
very
Yeah,
good.
thank you. By the way,
we're
we're back on air. Aloha. This is Keli'i Akina, President of Grassroots Institute, with Robert Thomas. We're talking about life, liberty, and property on the Ehana Kako weekly broadcast program on ThinkTech Hawaii. But before I go on, I want to say thanks so much to Jay Fidel and a crew of about 30 people who make it possible for us to be producing, I don't know, maybe 10, 12, 15 hours of live broadcast content, excellent content every week that goes across the world, that's on the internet, that is on radio, on television, and also make sure that you get a podcast or see the archives at thinktechhawaii.com. Well, back to a story that I think is so very important for us to understand as we start talking a little bit more about property here in the state of Hawaii. Robert, why don't you recap a little bit about the Kauai story and tell us the rest of the story?
Sure. You had asked about what's some of the highlights, or what is a good example of what Pacific Legal Foundation does. And this was a case that started with the voters of Kauai adopting a charter amendment limiting how the county could go up on their taxes every year. And it was a very popular measure passed by an overwhelming majority when it was put to the vote. But then, in kind of a shocking move, the very politicians who were against it sued its implementation, or sued against its implementation. And it's probably the most bizarre case I've ever come across, because you had the county mayor suing the county, trying to prevent implementation of a public law that the county itself had adopted through the charter amendment process. So it was simply bizarre that the mayor could, or the county could essentially sue itself.
Now, from the outset then, Pacific Legal Foundation or whomever approached you must have seen that there were some very deep issues concerning democracy at work over here. That this was not just about somebody being disadvantaged by another, but our very way of governance what was at stake.
Yes, and that was what got Pacific Legal Foundation interested in the case, and it was brought to us after the Kauai Circuit Court invalidated the measure, found in favor of the government, the Kauai County government, and the next stop was the Hawaii Supreme Court. And so since we do primarily appeals, they said, well, maybe you should come in on this. And we looked at it and we said, this is a case because it's about, it protects people's ability to stay in their homes. It also protects the fundamental right of people to have a direct say in their government. Now, we don't have initiative and referendum on the state level here, but I think virtually every county has similar measures, initiative, referendum, and in the case of charter amendments, the people can propose charter amendments that are then voted on. And because the voters of the county had adopted this by such an overwhelming margin, it wasn't even a kind of a close call. So we came in at the Hawaii Supreme Court level trying to get that circuit court decision overturned. And we came close, I must admit. There's 5 justices on the Hawaii Supreme Court, and in a 3-2 decision, we lose. And the rationale that the court adopted was when the state legislature delegated the state's power of property taxes in 1978 to the counties. When they used the words, we delegate the power to the counties, they actually meant the county councils. Therefore, the people were without the power to vote on these type of things, and only county councils could do it, which of course they never will. So the Hawaii Supreme Court decision regrettably shut down not only the Kauai measure, but similar measures in other counties that really would have, I think, helped homeowners really avoid the type of thing that we saw in the city council here in Honolulu last week. And it was very disappointing, a ruling. But that's the way the system works, and so because of that, it shut that out. And what was probably the most distressing was they were saying, your betters know better. Elected officials are supposed to be there. They work for us, but in this case, their desires, the desires of the county council on the county on Kauai, overruled the voters themselves, which just seems, even to this day, it rubs me the wrong way.
And the fact that, as you say, it rubs you the wrong way is part of that conviction, the fire in the belly that keeps you in public interest law. One of the things about public interest law, I think, is that it takes a long range rather than a short range frame of reference. I mean, in the short term, of course, we'd all like to win in our day in court. But in public interest law, maybe you could address this a little bit, isn't it the case that we're not only aiming to win the case in the court of law, but also the case in the court of public appeal, which makes a big difference. So do you think you've had some strides there where you may not have won in court necessarily?
Well, I think that was the case. I think that was a prime example, or one of the prime examples here locally. Another one was from 2005, the U.S. Supreme Court in what has become an infamous case out of the city of New London in Connecticut. 5-4 ruled in favor of the government that eminent domain, the power to take property or make you sell property, which we're becoming more and more familiar with here because of the rail, what the government says its purposes are is good enough. So if somebody is considered to be utilizing their property in such a way that it's not making the maximum that the government believes you should be making on it, then the government can take it and give it to somebody else or sell it to somebody else. And the city, in that case, won 5-4. And a 5-4 decision is as much the law as a 9-0 decision. So that is the law. But since it created such an uproar that even though the homeowner in that case lost definitive, I mean, she 5-4, she got 4 votes, the other side got 5, the court of public opinion overwhelmed the Supreme Court opinion, and 48 out of the 50 states, I'm sorry to say Hawaii is one of the 2 that didn't do anything in response to that case, even though we tried. 48 out of the 50 states adopted measures so that they hoped couldn't happen. The same thing couldn't happen regardless of what the Supreme Court said. And of course, another one, for instance, is the decision that led us into the Civil War. I mean, not to take too much of a historical view, but Dred Scott, Supreme Court decision ruling in favor of the slave owners.
3/5 human.
Yeah, precipitated the Civil War, and that's probably the most extreme example from U.S. history of the people or the public mood saying,
Certainly.
no way.
And going back to the eminent domain case, although Hawaii has not followed suit with the other 48 states, it is the case that we have a high level of practice of eminent domain in our state, compared to other states per capita.
Yeah, and the case that the U.S. Supreme Court relied on in that 2005 Connecticut case was actually a case that many homeowners and property lawyers here are familiar with, called Midkiff, or Hawaii Housing Authority against Midkiff. The case in which the Supreme Court 8-0 validated the legislature's the Land Reform Act, Chapter 516 of the Hawaii Revised Statutes, that allowed homeowners of single-family residences to petition the state to force the owners of the fees to sell at condemnation prices. And so anybody who owns a home here now and also owns the fee simple, that's the case that led to this.
And it's a perennial issue here, not only the right of the state through eminent domain to take property, but to determine the price that gets paid for
luckily, that's where the jury system kicks
Yes.
in, and that's the wonderful part of our system.
when you can afford to go through the legal process.
Yeah, and that's we've tried to change that after that 2005 case.
We should be posting your telephone number up
Boy,
here.
I mean, especially with the rail coming,
Yes.
there's so many people who have contacted us because eminent domain is one of the things that we do. And
we'll come back in just a moment. In fact, when we come back, Robert, I hope we can talk about a case where Grassroots Institute and you have gone hand in hand in terms of trying to defend liberty here in Hawaii. I'm Keli'i Akina, president of Grassroots Institute. My guest, Robert Thomas of the Pacific Legal Foundation, is talking about life, liberty, and property. We will be right back on the ThinkTech Hawaii Broadcast Network in just a moment. Thank you.
Aloha, I'm Nicole Horry for ThinkTech. For nearly half a century, the Hawaii Foreign Trade Zone No. 9 has brought the benefits of the Foreign Trade Zone program to Hawaii businesses and entrepreneurs. DBET, the Department of Business, Economic Development, and Tourism, operates Hawaii's Foreign Trade Zone program to encourage international business and economic development. The Foreign Trade Zone's mission is to increase the amount of international trading activity in Hawaii, thereby providing employment opportunities for the residents of our island state. For more information, see ftz9.org. I'm Nicole Horry. Mahalo.
It goes by very fast, doesn't it?
Yes, it certainly does. Aloha and welcome back to our final segment of E Hana Kākou for this week on the ThinkTech Hawaii Broadcast Network. I'm Keli'i Akina, president of Grassroots Institute, talking with my friend Robert Thomas of the Pacific Legal Foundation. At Grassroots Institute, we believe in limited accountable government, free markets, and individual liberty. And we can't preserve those rights without the work of lawyers who've committed themselves to understanding the law, fighting for what is true and just in court. And I have to say that Robert Thomas is really one of them. Robert, thanks so much. It's been full of insights talking with you today and working together. In fact, we were talking a little bit about how eminent domain law on the mainland has tremendous ramifications for what happens here in Hawaii. And so do other issues. For example, the city of Tombstone had a water rights issue. And people might be wondering, well, what in the world does that have to do with Hawaii? Or what does that have to do with the Grassroots Institute wanting to take a stand in that case? But as it turns out, whatever may happen anywhere else in the country could become a precedent for what happens here. And when it comes to water rights, well, take a look. Water is so precious and scarce here. Tell us a little bit about the city of Tombstone and its battle against the federal government for its water rights.
Well, it's a fascinating case, of course. Anytime you mention Tombstone, you think of, the
Well, I think of pizza.
You got me there. Wyatt Earp in the gunfight at the OK Corral. And in fact, this was, Tombstone, Arizona, out in the southern Arizona desert, not far from the border of Mexico.
You can imagine how important water rights are.
Huge, of course. And the source of Tombstone's water, they don't have wells they have a couple of natural springs up in the mountains that surround Tombstone. And that's the source of their municipal water. So fire, for water consumption, fire suppression, everything else relies on these two sources. Those sources happen to be in a national forest, which is federal government-owned land. And, they go back quite a ways, obviously, and then they're transported down from the mountains to the city. But there was a devastating fire up in the national forest a few years ago that really wrecked the city's ability to, or it jeopardized, it really was devastating. It jeopardized the city's ability to keep its water flowing. And they went to the federal government and said, let us go up there and repair those springs and our infrastructure built around those springs to capture the water and transport it down. And we need to bring in some backhoes and this and that and the other thing. And the federal government said, no, you can't do it. This is a national forest, and that's just totally degrading to the environment. But you can go up there with a work crew with some shovels and do it by hand. And so the city of Tombstone, being sort of these Wild West characters still, these sort of, just what you would imagine them to be, filed a lawsuit against the Secretary of the Interior. And eventually the federal district court in Arizona and ultimately the Ninth Circuit based out of San Francisco ruled in favor of the federal government. Said it's federal land, they can do what they want with it. It's just your bad luck that your water sources, your exclusive water sources, happens to be in federal public land, and if that's the case, too bad. And that's when we joined together, and I do want to make clear that when I filed the brief, it was not on behalf of Pacific Legal Foundation, but I was happy to do it in my second hat, is my private capacity as a lawyer. Grassroots Institute joined with about 3 or 4
other think tanks.
Including Cato,
sure.
To file a brief together telling the Supreme Court, because once the case was lost in the Ninth Circuit, the city of Tombstone asked the U.S. Supreme Court to take the case to resolve the very important issue under the 10th Amendment of what powers does a local government or a state government have when those powers clash with the desires of the ever-growing federal government.
Absolutely. In fact, I might interject here. This is the reason that members of the State Policy Network think tanks felt we had to act, because it wasn't merely a local issue. It had to do with the role and power of government to control that which really belongs to the people.
Right.
And that's a fundamental issue. That's one of the reasons that Grassroots Institute and the State Policy Network think tanks exist.
And what happened was, what I forgot to mention, was that the state of Arizona, Governor Jan Brewer, issued a declaration of emergency that under, the whole national, everything, that this was it wasn't something that the city of Tombstone just made up and was blowing out of proportion. I mean, if a fire had begun in the city, the taps would have been, might have been dry.
It was very serious.
And the question that was called in that case is, when a state or a municipality makes the determination that this is something we must do, not something we want to do, but we must do, what power does the federal government have to say you can't do it? And it's obvious, I think, why that became an issue, or became an issue of interest to Grassroots here in Hawaii, because so much of our land here is federal land, and we've got so many layers of government, and often they may conflict. What happens here if our water sources, wherever they might be, or our electricity, we're subject to a hurricane, a tsunami, and is it all of a sudden that we simply rely on whatever the federal officials, none of whom I elected, can tell the local city and county of Honolulu emergency management agency, you can't do that because you need to get on federal land to do something.
And it's especially delicate and subtle an issue here in Hawaii, because we rely so heavily upon the federal government
Yes.
for the military, for our economy, for so many aspects of life here,
Yes.
that maintaining the balance of preserving the rights of the people, the states, not as a political issue, but in terms of just the fundamental rights that are guaranteed by the Declaration of Independence, becomes something we have to be vigilant about. It's a balance that's difficult to maintain unless we have public interest law firms like yours, as well as you acting as a private attorney, working with groups like Grassroots to really go to battle. So we signed on, did this amicus, and so tell us the rest of the
unfortunately,
story.
the Supreme Court, the Supreme Court gets about 3,000 of these petitions a year, takes roughly 80. The statistics are against you, and unfortunately, in this case, the Supreme Court let the Ninth Circuit decision stand. But I think it's important. You can't necessarily reserve your participation in these type of cases to those you think you're going to win. So you have to keep at it, educating the court, other lawyers, and whatnot, even if it doesn't, the statistics are against you. And again, unfortunately, in this case, they were. But I thought it was a very educational experience for us to learn how to work together, for you to work with the other organizations in particular, see where there are those common themes. And ultimately, what it boiled down to was the reason I would prefer the city and county of Honolulu making a decision about emergency management is I elect those guys. I can walk down the street to City Hall, or I can go knock on the door of the administrators and the bureaucrats. But when it's the Secretary of the Interior making those decisions for me, how in the world do I go to Washington to figure out how do I get my voice heard? So
Absolutely.
it's all about local control over local issues. I mean, yes, we have the federal government, but when you tend to have this large, distant, in our case, we're I guess American Samoa and Guam might be further, but we're the furthest state from the seat of power, federal power. We should be very concerned anytime there's a surrendering of local authority to distant, unelected, in this case, unelected officials.
Well, that's a great note to stop on today, because we come full circle. We were talking about big ideas in the beginning, particularly those ideas of our founding fathers in the Declaration of Independence and the Constitution. And one of those ideas that it is government that we have, government of the people, by the people, and for the people. And so your work in public interest law helps us to preserve that. So Robert, thank you very, very much.
Thank you, Doctor, and let's go pursue happiness after this.
Absolutely.
Once we sign off.
Maybe maybe giving credit to Samuel Adams as we pursue happiness.
There we go.
Today. But I'm Keli'i Akina, president of Grassroots Institute. We appreciate your support for individual liberty, free markets, and limited accountable government. I'm so grateful to Robert Thomas and lawyers like him who work in public interest law, because they make it possible for citizens to preserve their liberties, and we need them very much. Thank you for being here. Thanks to Jay Fidel, ThinkTech, Hawaii Broadcast Network, and we'll be back again on E Hana Kako next week. Aloha.